fellow philosophical thinkers at an Open News podcast. My name is Craig, transmitting from the beautiful Swampy Main Woods of South Florida, and today's date is Tuesday, July 24th, 2018. Yeah, so lots of controversial incident has happened in Clearwater, Florida, which is in the Tampa Bay area. Something very horrific. That I can say in good faith, based on the video alone, without the audio, it could have been prevented immediately. Could have been simmered down. And of course, the folks out there are exploiting and manifesting the repeal, stand your ground law and all that. It makes us less safer. I'll be very frank. I lived in Florida for 41 years. It's been a dangerous world since the beginning of time. Crime is always going to occur everywhere you go. And what really disturbs me is that the mainstream news all jump on this confounded bandwagon and how the controversial law is. But the question is this: was it honorably implemented? The saying is, if there was audio on that particular video that happened at that Circle A convenience store, we really got a bigger picture. And I noticed too, the Pinellas County Sheriff's Office has exonerated him. However, the state attorneys are investigating. So he's not out of the loop as of yet. So I'm going to be narrating some of the stuff. And what's interesting is the claim that even the shooter himself, Michael Draga, wasn't the first time this happened. According to some news sources, I want some local news and Tampa Bay Times, all that. So I'll be mainly addressing that area and give you the facts about the Florida Standing Ground language and what it was originally about. It was an educational perspective. And of course, he's going to say, I've been hearing too on the news, they try to come match this to Trayvon Martin, which George Zimmerman was the shooter. And they try to use the stand your ground law there as well. And it's immaterial, to be very frank. Because the man was on his back. It was considered classic self-defense. Regardless, I never met George Zimmerman, never talked to him, never called him my hero. Or Lord and Savior, anything like that. I have to agree with Florida Carry. They made a statement about it on their Facebook page. Are not jumping the gun on this conclusion until all the information is out, official, from the investigation and so forth, which I have to say is very fair. It doesn't matter if the shooter was, regardless of skin color, national background, etc. It doesn't matter. Because if you heard my shows in the past, I read some of the reports about a couple of assailants that were white was harassing a black person in Illinois, and he defended himself, and it was justifiable, and I commended it. It was one of the areas you have to really observe. So expect the race baiting thing to really manifest. So my purpose is not to use that pretentious rhetoric. So I'm gonna narrate a whole bunch of stuff here, and I'm gonna add something. There's gonna be something added, regardless. It's not included this Florida Standing Ground as a whole. So the different news report I got from a colleague of mine, and I think people will share information on this. And so let's just see here on some of the sides of the story. I'm not going to go too bonkers. But this came out yesterday from ABCActionNews.com. WFTS Tampa Bay. St. Peter lawmaker rallying support to repeal standing ground. Changes after Clearwater shooting. You can see the video here for yourself. Of course, good morning, America. Everyone's jumping on this. Well, it says here, what if someone chose not to pull their gun and defend themselves? That one punch or shove causes their death. Then we're going to be saying why he didn't pull his firearm in self-defense. That's what the criminal attorney, defense attorney Escobar said. Explain. Escobar says the law makes it clear if you feel threatened, you can pull the trigger. There's other areas too. I'm going to explain it on the law itself. Escobar says the law makes it clear if you're threatened, you can pull the trigger. I think the real problem is people are afraid this will open Pandora's box, and that if you're being physically attacked by someone, you will automatically shoot. I don't see it that way. You pull out a gun to defend your life, he said. Diamond plans to try to repeal the law during this upcoming legislative session. As for mcglockton-drejkacase, the state attorney's office tells us it could take a long time for them to decide if charges will be filed. So it's still under investigation into a different institution. In the meantime, the McGlockton family has hired their own attorney, Michael Reiner of Reiner Robinson LCC. In the press release, the law office said they are urging the community and the nation to contact the state attorney's office to demand charges filed against Drejka. So they're going to be really pushing it and then possibly explore it. But I'll continue on here. And it goes on. Well, if someone, okay. That's only, oh wow, it's only one page? Interesting. Because sometimes they have 2 pages on this thing, and I really don't see that. Alright, well, that's one area for sure. So you're going to have everyone urge, demand charges now. You know? Well, before you do that, study the laws first. So that's one thing you gotta be careful. And right here is an interesting case over here as well about gunmen, a history of altercations. This is very interesting. It came out a couple of days ago, yesterday as well. This is from Spectrum News 9 in Tampa Bay area. Weeks before, Michael Drejka, 47, shot and killed Marquise mcglockton, 28, over parking spot. He crossed paths with Richard Kelly. Kelly, who drive respective tank, briefly parked his tanker in this handicapped spot outside the Circle A food store, running inside the store for a beverage. When he came out, he saw Drejka taking pictures of his vehicle. He asked me if I was handicapped, and I said, obviously I'm driving the tanker, I'm not handicapped. And I asked if he was handicapped, and he stated, no, my mom is, Kelly said. Kelly asked Drejka if his mom was nearby and offered to move the tanker. That's when he said Drejka became furious. He flipped out and called me every N-word. And he's going to shoot me, Kelly said. He said he was going to kill me, and he went back to his truck, got something out of his truck, and walked back up on me. Store owner Ali Salas came out and shut down the confrontation. I didn't know this was going to happen. 2 months later with another guy. It's really sad, he said. Salas said Drejka has history of confrontations in and around his store. He told me I can't help it. Every time I do this, I get in trouble and I can't help it. I keep doing it. Salas said. Kelly and Drejka called his job and left a Drejka left his job, called his job and left a voicemail on the answering service. Drejka has not been arrested for killing mcglockton because, according to Pinellas County Sheriff Bob Galtari, the shooting was covered under standing ground law, measure that allows people to use deadly force if their lives are in danger. McGlockton shoved Drejka to the ground after Drejka yelled at mcglockton's girlfriend for parking in the handicapped parking spot. July 26th, Spectrum Bay News 9 went to Drejka's home for a comment on the story, but no one came to the door. Kelly has given a statement about his run-in with Drejka due to investigators and is trying not to think about what could have happened to him. I'm grieving for the family right now that lost someone, he said. So, and if he made a threatening statement, how come that wasn't even reported as well? It would have been possible Michael Drejka's would have been on the hot seat, I would say. And of course, NAACP hosted a vigil for McGlockton Sunday evening. And of course, the NAACP is anti-self-defense, so they are pro-enslavement based on their past history. They don't want to see people of color defending themselves when it's necessary. And I know that for a fact because I've did a lot of homework on these people as well, on this organization. That's a complete turn-off too. They support no guns for Negroes or anyone else. But I might hear just giving you those claims, factual claims, based on their ordeal. And of course, Michael Drejka, the murderer, arrested him. So everyone's putting signs up on the person's store on his wall. And this is, like I said, it's very disheartening. Over a confounded parking lot. I'm gonna do a little homework here. Oh yes. But oh man. But one of those areas we have to look at is how far did this occur? And like I said before, could it be actually, was it necessary? But like I said, when I saw the video, in my view, my observation, he did backed off, Mr. McGlockton. And it was interesting because I was watching some video. Someone's looking at Mr. Drejka's Facebook page. He's a strange dude, man. A very strange individual indeed. And it looks like there's nothing here from Florida on him. I'm looking on mugshots.com. So it's one of those areas you got to look at. But the truth of the matter is I'm going to have to really see how far the investigation goes. And if he gets indicted, he could probably get possible second-degree murder or maybe manslaughter at the most. To be very frank. Possible manslaughter, I would say. But we're going to check on here for a couple more articles on Standing Ground. Of course, the political arena is going to be jumping on this bandwagon. On the buzz, a Tampa Bay Times, Standing Ground. On here on Standing Ground, Democrat, Republican, gubernatorial candidate split on what to do now. Of course, it'll be say the wrong words, it could jeopardize your election. And we'll just carry on here what they have to say. All 5 Democratic candidates expressed severe concern about the 2005 law with the most proposed and repeal and major changes. Republicans, Rob DeSantis, didn't respond to question, and Putnam supports the law as it is. How come they're not asking Rob White, who's running for governor? How come they put that in there? Explain that to me, Miss Emily L. Mahoney. It happened earlier today. Well, a good example of just how far apart 2 major parties in Florida are. Take reaction of the 7 candidates running for governor. Governor over last week's shooting death of mcglockton. Pinellas County Sheriff Bob Gubernatorial says his agency can't arrest Michael Drejka, even though the video clearly shows him shooting McGlockton. Gubernatorial said the shooting is within the bookends of your standing ground and within the bookends of force being justified. That's chapter 776 to be exact. Later added, I'm not saying I agree with it, but I don't make that call. The case has drawn national attention and renewed criticism of the 2005 law that continually gets blamed for fatal shootings throughout Florida. The people who make the laws, Florida legislature, and the person who signs the bill into law, the governor, has an outside say in making any changes to stand your ground. Governor Scott has been a big supporter. In 2016, lawmakers passed a law shifting the burden of proof to prosecutors in cases where defendants claim they were justified in using deadly force without first retreating. Scott signed the bill into law. What do some candidates who want to replace Scott think of the law now? Campaign Times sent all candidates the following question. Do you agree with Sheriff Garland's decision not to press charges? Does the shooting indicate changes are necessary with the SYG law? Would you propose any changes, or is the SYG law fine as it is? What changes, if any, would you propose? Here's how the campaigns responded. Andrew Gilliam, via Jeff Bergen, campaign spokesman. Those going to have someone speak for them on their behalf. Do you agree with Sheriff Garland's decision not to press charges? Standing ground puts law enforcement officials in an untenable situation and puts people at risk of being gunned down in everyday life. This senseless tragedy highlights why Mayor Gilliam has called for the repeal of this law. Yes, if you are a governmental delegate, like you got some rogue elements in the police department, can do whatever they want. That's called exceptionalism, right? But remember, too, I will continue on here. I'm not going to digress. Does the shooting indicate changes are necessary with the stand your ground law? What changes, if any, would you propose to the stand your ground law? The mayor said, before we need to repeal the stand your ground, the law that the NRA has pushed around the country. The recent change to the law that would move the burden from defense attorneys to prosecutors forces law enforcement to simply take the word of someone who has shot another person in self-defense. Gwen Graham, all of us agree with the right to self-defense, but have a great concern about whether stand your ground law is applied fairly, if it actually encourages more confrontations. After the death of Trayvon Martin, we should have examined how to reform the law and protect more Floridians. But instead, the legislature actually expanded the law. Sadly, in Pinellas County, again, we've seen consequences of this ill-conceived policy. Someone else is dead because someone chose confrontation when there were others options. Excuse me? And I'll say this again, Miss Graham. Why are you lying to the people that's reading this newspaper? If you were listening to the case about what happened, it has nothing to do with stand your ground with Trayvon Martin, which I think is horrible. It really disturbs me big time. Regardless, they're going to use that case, which was proven, it was on his back. Classic self-defense. See, right there, Gwen Graham is a liar. Trying to sell you something, trying to sell you a faulty product. I'll continue on here. As governor, I will lead an effort to reform the law to ensure people who are legitimately defending themselves can do so without creating a legal loophole for criminal behavior. It will also create a task force of prosecutors and civil rights leaders to take every stand your ground case to ensure that the law isn't allowing criminals to slip through the cracks. Even if you do that, criminals will shoot at people that they don't give a damn. Remember, that's their mind. A lot of them have that mindset. How many people they can violate. This also must be a part of large conversation on common sense gun safety. As governor, I will implement universal background checks, ban military-style assault weapons, and ensure domestic abusers can't obtain guns in order to stop daily violence that plagues communities across our state. So what you telling me, Miss Graham? You're against the militia. You're against basic rights. And you can prove to me the police are obligated to protect an individual in Florida. You can't. End the drug war for one. All right, and assure domestic abusers. Is that without due process? The so-called take the person's firearms if there's an alleged allegation? Pretty vague answer, I would say. Jeff Green. It would be remiss to make a conclusion without all the facts in this specific instance. but standing ground laws urgently needs revision. They give people shoot first, think later mentality. This has been used disproportionately to defend white on black and brown crime. There's a tragedy for the McGlockton family. See, he's trying to use the race card. Mr. Green. Very naive of you, sir. A Palm Beach billionaire is trying to tell me how to live and wipe my rear end. But the whole thing is this, my friends. If people really look at the stand your ground in Florida, and unfortunately, Tampa Bay Times had a great investigative report around 2012. It was pretty damn accurate. I'm very disappointed he took that down, because what I read, it benefited the African American community a lot more. Black on black, white on white. It doesn't matter with this whole interracial thing. Please, don't waste our breath, Mr. Green. That's very dishonorable of you. You're going to run for governor of Florida? You should just step back, because your racial division is your business. Chris King, there is no question that we need to take a hard look at the law. I fear it encourages Florida to make some justice judgments. Shooting first, ask questions later. Standing ground should be reformed to fit within American constitutional and legal traditions and restore an individual's duty to retreat. So, I don't know what the hell that person's talking about, but I don't really buy it either. Philip Levine, the man that hates freedom, was mayor of Miami Beach. He hates free speech, by the way. Do you agree with Sheriff Gullery's decision not to press charges? When a shove leads to someone being shot dead and law enforcement can't even arrest the shooter, something is very wrong with our gun laws. I'm in favor of self-defense, not a license to kill. Unfortunately, this is what stand your ground has become. Can you tell me why some of the Miami Beach fires been shooting the crap out of some people at the past Memorial Day weekend events? Yeah, explain that to me. Does the shooting indicate changes are necessary with the standing ground law? Again, I understand why Floridians believe self-defense should be in place, but standing ground has become nothing more than a license to kill. See, right there, he's selling you more malarkey. I'll go on here. What changes, if any, would you propose to stand your ground law? Stand your ground law is being interpreted today as the NRA's most dangerous piece of legislation they have passed. This is why we must repeal it and begin with a new starting part when it comes to some real self-defense laws on the books. I'm just wondering what kind of stuff is that you're talking about, Mr. Levine? Tell me again, when you're mayor of the city of Miami Beach, are the police obligated to protect an individual? Absolutely not. If not, if you disagree, prove me wrong. Republicans, Adam Putnam. I stand with our law enforcement. Law enforcement does that and enforces the laws passed by legislators. Sheriff Gullery and all our county sheriffs are faced with tough situations every day and must make decisions within the bookends of the law. The case has been forwarded to the state attorney's office for final review. Like them or not, fair enough. It doesn't need to be a Republican, but that's why it says they have to look at more thoroughly and make a decision. Via Putnam campaign spokeswoman Meredith Patrice. Adam Putnam supports standing your ground and believes Floridians have the right to defend themselves, their families, and their properties when they are threatened. The specifics of this case are still being reviewed. And what's funny about that, with the stand your ground law in Florida, is long before this came into effect in 2005, it's been common law in Florida. If someone comes in your house uninvitedly breaking your home, you are entitled to use deadly force. It has nothing to do with stand your ground. It's common law, Castle Doctrine. So when people try to combine this with stand your ground, it's null and void. Rob DeSantis didn't respond. Well, you know what? I would say this is very touchy situation. Of course, Florida Attorney General's candidates react, stand your ground should be repealed. But one of those areas I gotta look at is they're gonna try to sell you a bad product. And I don't care what side you're on, regardless of partisanship, I'm going on principle. I support principle over party. That's what I'm saying. I'm expecting the state attorney may overturn this. I wouldn't be surprised. But it doesn't mean, if it's second-degree murder in Florida, if I'm correct, they have a grand jury to review it, which they should have done with the George Zimmerman case, in my honest observation. It can be done on both sides. So, but very interesting too with Michael Draga. He said it wasn't the first time. How many other people he may have harassed? Like I said, it's like a weird-looking guy. So, I'm going to continue on here. On this, I know I'm ranting too much. Everyone talking about the experts here, all these stupid opinions I've been hearing. So, it's true that Tim Burton said here George Zimmerman did not raise stand your ground in his defense. He just used a regular self-defense arguments he pinned to the ground by Trayvon Martin couldn't retreat. Research has shown that gun murders in Florida have increased since stand your ground was passed. Have all the stand your ground cases in Florida have been closely analyzed to see which shootings were all justified. That's a fact. And here's the thing too, my friends. A lot of people, there's 2.5 million cases. People use firearms to defend themselves, families, and property. And there are a lot, awesome, a huge amount of times, didn't have to shoot criminal block flags. Well, just check this out here about the public safety. Same thing about Tampa Bay Times. I guess I use this because it's near the area. And it says here 5 times Florida standing ground law sparked controversy. This is by Kirby Wilson. Came out yesterday. Florida controversial self-defense law is in the news again. Killing of Marcus McGlockton, a 28-year-old who was shot by another man after the two argued over a parking space on Thursday. It is just most recent in the long succession of controversies over the law coming known as Stand Your Ground. Pinellas County Sheriff Bob Galatieri announced his office wouldn't charge McGlockton's killer, 47-year-old Michael Draga, on Friday. Here's a look back into the Tampa Bay Times archive for 5 times Stand Your Ground, which exempt from prosecution those who use deadly force to protect themselves if they fear for their lives, has made news. And there's from the archives here, Stand Your Ground laws protect those who are far beyond that point. And of course here, 2012 death of Trayvon Martin, in perhaps the most famous Stand Your Ground case ever. George Zimmerman was acquitted of second-degree murder and manslaughter after killing Trayvon Martin, an armed black teenager. This is here on February 26, 2012, Zimmerman called on the police on Martin, who was walking through his neighborhood because he suspected Martin may have been connected to a string of local burglaries. Martin, who noticed Zimmerman following him, began to run away from the neighborhood watch volunteer. Police told Zimmerman he didn't have to pursue Martin, but Zimmerman did anyway, according to Competera's news report. The 911 call placed by Zimmerman to eventually have gotten to an altercation in which Martin left Martin dead. What's interesting about that, because according to the investigation, the dispatcher, you can look this up yourselves, please, that he actually, when he started continuing to pursue, dispatch stopped and he did comply. So, you gotta make sure the information is very accurate. But I'm gonna continue on here. Zimmerman was arrested and charged with second-degree murder, manslaughter. He claimed self-defense under the broad Stand Your Ground law, citing injuries he sustained in the confrontation, and in 2013 he was acquitted. Martin's death and Zimmerman's acquittal sparked national protests, helped give rise to the national Black Lives Matter movement. And he never used Stand Your Ground. It was classic self-defense. The man was on his back. Sometimes you see these rioters that can throw those buzzwords in. It's part of the Everybody's playbook propaganda. The 2014 Pasco County movie theater shooting. On January 13, 2014, Curtis Reed, a retired Tampa police captain, took exception to a fellow moviegoer's cell phone used during previews at a Wesley Capitol movie theater. He asked the man, Chad Olsen, to turn off the phone. The two began to argue. Olsen threw a bag of popcorn at Reeves. Reeves responded by shooting Olsen in the chest and killing him. Reeves has tried to claim self-defense under standing the ground law, but he has thus far been unsuccessful. In May, an appeals court denied his challenge to the 2017 ruling. He was not exempt from prosecution under the law. The trial date for Reeves has been set for February 25th, 2019. However, it is unknown to what extent recent changes to standing ground law passed by foreign legislatures could affect Reeves' case. We'll probably go back to the old laws anyway. But, and it's, you know, why the hell are you going to go use a cell phone in a movie theater? You know, these folks, it's like, it's disturbing because you got people out there believe the world should revolve around them. If you're going to use it, take it to the lobby. Good grief. Well, I'm going to continue on here. The case that started all in 2004. Florida lawmakers cited the case of James Workman, 77, when they called for a change to existing criminal law in 2004. Workman shot and killed Rodney Cox, 35, after Cox entered his home in the middle of the night of November 2nd. Legislator bemoaned the fact that Workman had spent almost 3 months in legal purgatory before the authorities announced he would not be charged in Cox's killing. They were entitled to protect the castle. Darrell Peden, the Republican state senator who sponsors Stand Your Ground law, said in 2005, why should he have to hire a lawyer to say this guy is innocent? However, as 2012 Tampa Bay Times story notes, the fact case was not as simple as lawmakers presented them. Workman never hired a lawyer. Cox did not interact with Workman until after Workman walked outside to confront the man lurking in his yard. It was not only Workman fired a warning shot into the ground that Cox, who was likely intoxicated at the time of the incident, entered Workman's home, per the 2012 story. According to the story, Workman felt conflicted about the National Rifle Association back law in their case spawned. We didn't ask for any of this. Workman's wife, Catherine, told the Times that Workman said in 2005 he was kind of in favor of the law, but he can see some pitfalls if you make it too loose. And of course, even Tampa Bay Times didn't talk about the pros and cons of that in their past investigative report, which they took it off. They should put that back on there again. Good grief. I'm going to have to get a copy of that on paper. And so, and the person, and Mr. Cox should never went to the person's home. He chose poorly. Look what happened. Respect people's lairs. I don't care if you're intoxicated or if you had an erection. It doesn't matter. Well, I want to proceed here. Tampa man kills father of 3 in 2015 calls for standing ground hotline. In early hours of September 19, 2015, Nick Julian IV made 2 important phone calls. First was a call to 911 to report that he shot an unarmed man who claimed he attacked him. The second was to the U.S. Concealed Carry Association, at which time offered inexpensive legal counsel for members who found themselves in Julian's predicament. Julian, 26, had been arguing with Carlos Garcia for several minutes because of loud music coming from Garcia's car. Julian confronted Garcia about the music several times, and eventually the incident became violent. According to the shooter's father, Garcia chased after Julian before Julian shot him. He came at me with something, I don't know what it called, because it was dark, so I started to go towards my door. Once he got me towards my screen door, I just had no choice. I'm on my property. Julian told police dispatcher the 911 call. 2 months after the shooting, Hillsborough County State Attorney Mark Albert said he will not press charges against Julian. Like I said, more folks out there better have to. I'm going to continue on here. Thursday, number 5, mcglockton, 28, has exited a parked in a handicap spot outside his Circle A food store on Sunset Point Road near Clearwater. He went into the store to buy chips and a drink, leaves his girlfriend and 2 of their children, age of 4 months and 3, in the car. He took his 5-year-old with him into the store. Michael Drejkacase, 47, a man with a reported history of taking exception to legal parking at the store, confronted McGlockton girlfriend Brittany Jacob after searching outside for the car approved would occupy a handicapped space. A video taken of the incident showing McGlockton exit the store and shoving Draco to the ground. Draco then pulled a gun and shot McGlockton in the chest. He owned the gun legally and had a concealed weapons permit, already said. Friday, the sheriff announced Draco's actions met with the legal definition of self-defense. According to your comments, now, according to Gordon Martin, I have to agree with, I don't know how many times I heard the lie that Zimmerman, you stand your ground as a defense, and he's right. I've read it too, and I don't know why the past archives from the standing ground site they had talked about it too. And so let's give you some examples. And and of course, one Federico Alvarez said, video shows a large man shoving an older man to the pavement unprovoked, even if the provoked is no reason to put his hands on someone. The older man on the ground feared for his life and ended the attack before sustained further greatly bodily harm. And if you looked at the videos of Gordon Martin, you can see that the violent man was wrong for his actions, retreating after shoving the old guy who was not old at all, the shooter who was instigated the altercation in the history of doing so, telling the people he will shoot them. He was not in danger. He pulled and drew his gun, but both were in the wrong. While standing ground should not be used when person claiming it's the initial aggressor. So it's always like implementation. That's the name of the game. And when it really comes down to it, based on these stories and what just happened horrifically, folks, let's show some respect for one another, for goodness sakes. Everyone gets in their high horse and sometimes it has a sissy fit, and makes it into a bigger burden. Okay, and of course, what happened over there? Could that person may have been trapped themselves? Yeah. It could be a police officer maybe doing that. Find out if you're in there parked illegal. But based on some of the stories I got, Mr. Draco, one of the first time, is he trying to play neighborhood cop? Like I said, people see his Facebook page. He's a strange dude. Indeed. I'm going to have to look a little further about this character. Well, but one thing we got to look at for sure, my friends, don't fall for the divide and conquer game. The whole division and so forth. Look at the bigger picture. See things a lot broader. Let's see how far this goes with the state attorney's investigation. Can be overturned. Has happened before. And remember, too, the whole stand your ground case law is not 100% guaranteed. But the mainstream media don't want you to know that. And even some of the even RT Russia Today did talking about standing your ground and Trayvon Martin a while back, and they don't even have a damn clue what they're talking about. Yes, I get disappointed with some of the people who talk about that. So don't talk out of your rear end. So I'm gonna talk about a couple more about the laws itself, what it means, and I'll be right back. Alright, so speaking of that, I'm gonna hit some of the areas here on self-defense and standing ground. It's from the National Conference of State Legislators. As it reads here, it came out on March 9, 2017. The common law principle of Catholic doctrine says that individuals have the right to use reasonable force, including deadly force, to protect themselves against an intruder in their home. The principle has been codified with the expanded state legislators. In the 1980s, a handful of state laws, nicknamed Make My Day laws, address immunity for prosecution in use of deadly force against another who unlawfully or forcibly enters a person's residence. In 2005, Florida passed a law related to Catholic doctrine, expanded on the premises where stand your ground language related to self-defense and duty to retreat. Florida's laws states a person who is not engaged in an unlawful activity who is attacked in another place where he or she has a right to be, has no duty to retreat, and has a right to stand his or her ground and meet force with force, including deadly force. If he or she reasonably believes it is necessary to do to prevent death or great bodily harm to himself or herself or another, to prevent a commission of a forcible felony. The laws in at least 24 states allow there is no duty to retreat an attacker in any place which is one of the lawfully present. Alabama, Alaska, Arizona, Florida, Georgia, Indiana, Kansas, Kentucky, Louisiana, Michigan, Mississippi, Missouri, Montana, Nevada, New Hampshire, North Carolina, Oklahoma, Pennsylvania, South Carolina, South Dakota, Tennessee, Texas, Utah, and West Virginia. These one of those 9 states include language stating one may stand his or her ground. Alabama, Florida, Georgia, Kansas, Kentucky, Louisiana, Oklahoma, Pennsylvania, and South Carolina. Pennsylvania's law, amended in 2011, distinguishes the use of deadly force outside of one's home or vehicle. It provides in such locations one cannot use deadly force unless he's really relieved or imminent death or injury, and either he or she cannot retreat in safety if the attack displays or used as a lethal weapon. Self-defense laws in at least 22 states: Arizona, Arkansas, Colorado, Florida, Georgia, Idaho, Illinois, Kentucky, Louisiana, Maryland, Michigan, Montana, New Hampshire, North Carolina, North Dakota, Oklahoma, Ohio, Pennsylvania, South Carolina, Tennessee, West Virginia, and Wisconsin provide civil immunity under certain defense circumstances. Statutes in at least 6 states, Hawaii, Missouri, Nebraska, New Jersey, North Dakota, and Tennessee, assert that civil remedies are unaffected by criminal provisions of self-defense law. In recent years, a handful of proposals to enact such new laws have not advanced. Likewise, recent bills to amend or repeal certain aspects of standing ground laws and new duty to retreat self-defense laws have not advanced. There's interesting facts on those areas. So leaving a lot of those states too, some of them may not be, some of them may be surprised. Like New Jersey, is it New Jersey? Yeah, New Jersey, like there are some certain conditions on self-defense. So I'm just going to have to give you a little synopsis on that area because, hey, like I said, it's a natural born right. Defend yourself, defend yourself, families, loved ones, property, innocence, etc. Cannot leave state idly when your brother's blood is being exposed. And of course, you got a lot of folks out there. If it happens to their heirs, they like to start trouble, and if something happens to them, they all go up in arms. That's another thing too. Oh, you could have went to college and say, yeah, so how come that person chose poorly? And they don't want to say anything. They get all sensitive. And that's why I tell folks, you gotta exercise your actions wisely. Don't go around harassing people and screaming and yelling at one another. Even a person like my age, like what Drake is doing. I'm 49, so I'm close to his age. I'm not gonna go around, maybe some finesse, yes. So let's just check this out here on Florida Statutes 98 about justifiable use of force. It was just Title 46, Section 13, 776, Section 13. Home protection, use or threaten the use of deadly force, presumption of fear of death or great bodily harm. It is in 776.03. And it says here, 1 of this section. A person who is dwelling or residence in which a person has a right to be, has no duty to retreat, has a right to stand on his or her ground and use or threatening to use a non-deadly force against another when and the extent that the person reasonably believes that such conduct is necessary to defend himself or herself or another against other intimate use of lawful force, or B, deadly force if he or she reasonably believes that using or threatening to such force is necessary to prevent imminent death or great bodily harm to himself or herself or to another or to prevent commission of forcible felony. 2, a person is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to himself or herself or another when using or threatening to use defensive force that is intended or likely to cause a great bodily harm to another if A, the person against whom defensive force was used or threatened was in process of unlawfully and forcibly entering or had unlawfully or forcibly entering a dwelling, residence, or occupied vehicle, or if that person had removed or was attempting to remove another against that person's will from the dwelling, residence, or occupied vehicle, and B, the person who uses or threatens to use defensive force knew or had reason to believe in an unlawful enforceable entry or lawful enforceable act was occurring or had occurred. 3. The presumption set forth in subsection 2 does not apply if A. the person against whom the defense force is used is threatened has the right to be in or is a lawful resident of the dwelling, residence, or vehicle, such as owner, lessee, or title holder. There is not an injunction for protection for domestic violence or a written pretrial supervision order of contact against the person, or B, the person or persons sought to be removed is a child or grandchild or is otherwise in the lawful custody or under lawful guardianship of the person whom the defensive force is used or threatened, or C, the person who uses or threatens the use defensive force is engaged in criminal activity or is using the dwelling, residence, or occupied vehicle to further a criminal activity, or D, the person against whom the defensive force is used or threatened is a law enforcement officer as defined in statute 943.10 subsection 14, who enters or attempts to enter a dwelling, residence, or a vehicle performance of his or her official duties, or officer identifies himself, or in ordinance with an applicable law, and the person using threat of force reasonably should have known that the person entering or attempting to enter was a law enforcement officer. So technically the officer has to present himself with merit. He can't just walk in, crash in, and do all these warrantless searches, or not knock and smash, whatever you call that damn thing. 4. A person who unlawfully and by force enters or attempts a person's dwelling, residence, or occupied vehicle is presumed by doing so with the intent to commit an unlawful act and involve force of violence. And 5. As used in this section, the term dwelling by means or conveyance of any kind, including an attached porch, whatever the vehicle of conveyance is temporary or permanent, mobile, immobile, or has a roof over it, including a tent. And it's designed to be occupied by the person lodging there at night. Interesting. B. Residence means a dwelling in which a person resides either temporarily or permanently or is visiting as an invited guest. C. Vehicle means the conveyance of any kind, whether or not motorized, which is designed to transport people or property. Very intriguing indeed. On 776.013. So even if you live in a camper, someone breaks into there, you are entitled to use force. But it's necessary. Necessary force. Justifiable. So what area are you going to lower stand your ground? It would be, of course, subsection 1, A through B. Subsection 1 of this act or statute. Or 2. So they're going to try to rearrange that. Retreating is the answer. I'm sorry, the police aren't obligated to protect me. Some of you gotta look at things across the board. This is why you have to question the whole Drejkacase case too. The guy, like I said, the person stood back. Yeah, he chose for shoving the person, Drake. But when Drake pointed the gun at McClockton, right? Or maybe it, McClockton. It's big question. Like I said, in good faith, he has McGlockton, excuse me. He's still be further free. He was actually backing up. But like I said, I want to get all the actual information as well before I make my own decision. But based on what I've seen so far, it could have been prevented, period, across the board. Like that's what I say, folks. Respect each other. Don't play superhero. Don't play sweet pie purebred in heat. Okay, the person parked there illegally. I'm not going to argue about that. But going around playing Inspector Gadget and start having an argument with the person, the way he's facing his hand motion, instead of being finesse, would have been a little bit different. everyone could exhibit themselves a lot better. I can say that for sure. Yes, sometimes it's very disturbing regardless, but everyone will point their fingers, blame the law, blame the NRA and all that. It doesn't work. This is why, my friends, if you believe repealing stand your ground is going to make these changes, I wouldn't guarantee it at all. Well, let's say we'll just wait and see what happened in this particular case. And like I said once again, stand your ground is not 100% guaranteed. Get out of jail free card. Enough of that. Here's something interesting that came out today, around 12 noon. It's entitled, Florida Appeals Court Uphold Right to Carry Gun in Public. It's by Reuters. That means that one kid who, let's continue on here. It's by Reuters. A federal appeals court ruled on Tuesday that the U.S. Constitution's Second Amendment protects the right to openly carry a gun in public for self-defense, rejecting the claim by Hawaii officials that the right only applies to guns kept at home. Ruling by a three-judge panel on the 9th U.S. Circuit Court of Appeals makes the San Francisco-based court in the 6th U.S. Circuit Court to interpret the Second Amendment this way could set an issue on the path towards the U.S. Supreme Court, which has not taken up any major gun rights case since 2010. The extent to the right of gun ownership is one of the most hotly contested debates in the United States, where mass gun shootings have become almost commonplace. Yeah, because they're exploiting the daylights out of it. But when you hear about people using it for self-defense, they try to sweep it under the rug. In a split to a 3-2 decision on Tuesday, the panel found Hawaii infringed on the rights of plaintiff George Young when they twice denied him a permit to carry a gun outside. Why do you need a permit? It's a natural-born right, not some privilege. We do not take it lightly, the problem of gun violence, Judge Dermot O'Scallion wrote in Tuesday's ruling. But for better or for worse, the Second Amendment does protect the right to carry a firearm in public for self-defense. So the whole thing is, you got violent crime and the Second Amendment don't go hand in hand. The Ninth Circuit Court had ruled in 2016 that the Second Amendment does not guarantee a right to carry concealed firearms in the public in Petroria versus County of San Diego. The U.S. Supreme Court declined to rule on that decision last year. President Trump, a vocal gun rights supporter, is seeking to vacate Supreme Court seat to make the court more conservative, raising the prospect that it may take more cases in coming years. Alan Beck, a lawyer for the plaintiff, in Tuesday's ruling said he believed the question of openly carrying firearms will eventually end up before the Supreme Court. Why? It's a natural-born right. But remember, they all rely on the court system, and all these people rely on themselves, reading themselves, a bunch of damn illiterates. I mean, of course, they got lawyers that are against natural-born rights, so they'll be losing money, right? Absolutely. I think the Supreme Court is receptive to this, Beck said in a phone interview. The attorneys for the state of Hawaii were not immediately available for comment, but who the hell cares? We use the Constitution, you bunch of illiterates. Judge Richard Clifton dissented from Tuesday's ruling, saying the Second Amendment does not preclude the sort of licensing rules. I don't care, not today. Rules in use in Hawaii and elsewhere. Laws open to carry firearms by widely state and type of gun. The most restrictive are California, which falls under the Ninth Circuit Court's jurisdiction. Florida, Illinois, and the District of Columbia, which generally prohibit people from openly carrying any sort of firearm, according to Giffords Law to Prevent Gun Violence, a non-profit policy organization that favors greater gun control. Of course, because they want a police state. Giffords Law Center wants a police state. They want to leave all your security in the hands of the government, and you know what? It's nothing more than a wet dream. But even though they in Florida and Illinois, your natural-born rights are guaranteed. So you know what, Gifford Law Center? Penile microphone to you. You can't prove me wrong. Hawaii is one of the 15 states that require a license to permit to openly carry a gun, according to Center's data. In 2008, the U.S. Supreme Court ruled for the first time that the Second Amendment protects an individual right to keep and bear arms, keep guns at home for self-defense. The Second Amendment was adopted in 1789 Reason of well-regulated militia being necessary to secure the free state, the right of people to keep and bear arms shall not be infringed. And don't forget the Ninth Amendment as well, enumerated rights, which certain natural-born rights cannot be disparaged, distraught, infringed, abridged, etc. What's funny about the Hawaii Constitution, I didn't remember reading about that. I'm going to take a little swig. At this, but I know it's in there on the right to bear arms and natural-born rights. And of course, the lawyers in Hawaii don't. These governmental idiots in there, they'll want you to know that. They believe they are smarter than the supreme law of their own confounded state. Don't worry, people in Florida have the same aspect. You got these lawyers, governmental entities that hate liberty. They are the enemies of natural-born rights because it will hurt their business. I'm so sorry for them. Precisely. So, we'll hit the ballotpedia.org. I'm going to add this to my footnotes as well. Out of all fairness for all my friends out there who are listening to the show. And you can go to Ballotpedia anytime you want. Look at your states as well on their rights. Natural-born rights. They get so offended when I talk about natural-born rights. How dare you? Actually, there's one right here. Bill of Rights, Article 1 of the Hawaii State Constitution. And I like what it says here, that all persons free by nature are equal and inherited inalienable rights. Among these rights are the enjoyment of life, liberty, the pursuit of happiness, and acquiring and possessing of property. These rights cannot endure unless the people recognize their corresponding obligations and responsibilities. That means you don't violate other spaces. So right there, Article 1, Section 2 does supersede their right to carry law. Their concealed weapons permit. Alright? And we'll just go on here. Oh, hit 17, right to keep and bear arms, right? Yeah, we can hit that. So the rights of individuals, exactly. And we'll just come around here. We'll hit the right to keep and bear arms, shall we? Yeah, why not? That will be Section 17. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So you know what? Your concealed carry permit law is null and void. Will you please wipe your rear end on that provision because it does not supersede the supreme law of Hawaii. Kumbaya. And you know what? The truth of the matter is those dingleberries hate the truth. Ha 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 ha. That's how pathetic some of these individuals are. Yes, I like to be immature once in a while because, hey, they reap what they sow, correct? That's just an example. And we just hit one more thing here, shall we? No citizen shall be disenfranchised or deprived of any rights or privileges secured to other citizens unless by the law of the land. Well, that's Section 8, Article 1, Section 8. And anything else in here? Not really. Okay, cool. So I'm going to leave the Article 1 of the Constitution of the State of Hawaii. So it's self-explanatory. And hopefully the lawyers, the state attorney's office, the prosecutors of Hawaii will read it. If not, it should be disbarred for breaching their oath, including the politicians in that area as well, and anyone else that's against natural-born rights. Deep down inside, they know I'm right. Too bad, because the truth really hurts. Okay, my friends, once again, thank you for your time. But feel free to download and share it to social media networks. If you have any questions, comments, if you send something that's interesting you may want to check out, whatever you do, please address your correspondence with decorum. You can hit me on Facebook, Twitter, Google+, Spreaker, iHeartRadio, Tumblr, YouTube, Freedoms Network, Minds.com, FutureNet.club, Patreon.com/Web3 if you can be a patron, Gab at Gab.ai, Yours.org, OneWay.com, and Buylist.co. In addition, you can email me at LookAtLuck3 at gmail.com, or the encrypted ones, email the Proton Mail account, LookAtLuck03 at ProtonMail.com. Woo! Okay, my friends, once again, thank you for your time, but always remember that the demoniac resistance helps the soul and can liberate humanity. Until next time, take care of yourselves, keep on spreading love, and may your guardian spirits be with you.